Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And thank you for subscribing to my YouTube channel if you're new. We're going to talk about a very important topic today, which goes to the heart of most foreclosure actions, and let's get started. Okay, so we're going to talk about defective assignments in foreclosure. So why does this topic matter? Defective assignments are one of the most common and most misunderstood problems in foreclosure cases. An invalid or void assignment can destroy standing, break in the chain of title, and undermine a plaintiff's right to enforce the note or foreclose on the property. This presentation focuses on how to spot defective assignments and why they matter legally, and how to use them effectively in litigation. What an assignment is and is not. What an assignment does. An assignment is supposed to transfer a specific interest in a mortgage or deed of trust. Identify the real assignor with authority. Identify the real assignee capable of receiving the interest. Be executed by a party with legal capacity at the time of execution. What an assignment does not do, an assignment does not create ownership of a loan out of thin air. It does not cure defects in the note, or prove possession of the note, or automatically confer standing. Assignments transfer security interests, not enforcement rights by themselves. Standing starts with a valid assignment. In both judicial and non-judicial states, the foreclosing party must show authority. Authority depends on a valid chain of title. A broken assignment chain equals lack of standing. Key concept: a party cannot assign what it does not own and cannot receive what legally no longer exists. Common types of defective assignments. Assignments from defunct or non-existent entities. Red flags: an assigner went bankrupt, dissolved, or ceased operations before the assignment date. Assignments from entities like long defunct lenders, trusts that closed years earlier. A legal impact is assignment is void, not voidable. No standing can be derived from a void instrument. Assignments into closed or defunct trusts. Securitized trusts have cutoff dates and closing dates, and they cannot accept new assets after closing. Red flags: assignment dates years after the trust closing. Trust listed as assignee despite SEC filings showing termination. Okay. And legal impact: violates trust documents. Assignment is void under trust law. Robo-signed or unauthorized assignments are another one. Red flag: servicer or assigner lacks corporate authority. The same signer appears across many banks. Titles like vice president of multiple unrelated entities. The legal impact of this is no proof of authority, and assignment lacks legal execution. MERS assignments without underlying authority are another issue, guys. MERS as a nominee, not a lender. The red flags are MERS assigning on behalf of an entity that no longer exists, no longer owns the loan. The legal impact: MERS cannot assign what the principal does not own. Another thing is backdated or fabricated assignments. Red flags: assignment executed after foreclosure began. Assignment recorded just before summary judgment or sale. Legal impact: evidence of manufactured standing. Courts disfavor retroactive authority creation. Void versus voidable assignments. There's a critical distinction here, guys. Void assignments are legally non-existent and cannot be ratified. They can be challenged by the homeowners. Here's an example. An assigner lacked interest. The trust was closed. Entity was defunct. Voidable assignments are technically flawed but correctable, often require action by the parties to the assignment. Why this matters: homeowners generally have standing to challenge void assignments even if they were not a party to them. but voidable is tougher to challenge. How defective assignments show up in real cases. Common litigation patterns, multiple plaintiffs claiming authority, servicer changes without ownership proof, assignments recorded only after litigation begins. The real world takeaway, if the assignment looks rushed, late, or illogical, it probably is. How to use defective assignments procedurally. Plead them early. Plead them in lack of standing, failure of condition precedent, or void assignment allegations. Discovery targets, request, assignment authority documents, trust closing documents, SEC filings, corporate resolutions. And when you're in summary judgment, assignments contradict standing claims, the plaintiff cannot meet the burden of proof. For quiet title actions, a void assignment equals a cloud on the title. Court can declare the assignment null. Evidence that strengthens assignment challenges. Useful exhibits, recorded assignments, the SEC Form 15 filings, trust prospectus and PSA excerpts, bankruptcy or dissolution records, FDIC records, common defense arguments and how to respond. The borrower lacks standing to challenge assignment, that's common. Your response would be, borrowers may challenge void assignments. Standing exists when foreclosure authority is at issue. Assignment is irrelevant because note controls. In that one you say, well, security interest enforcement requires both the note and the mortgage authority. So the plaintiff must connect the two. Key takeaways for homeowners. Always check the assignment chain. Look at the dates, entities, and authority. Late assignments are never harmless. Standing must exist when foreclosure begins. And closing thoughts are, defective assignments are not technicalities. They go to the heart of who has the right to take someone's home. If the paperwork is broken, the foreclosure is broken. So let's take a look at some examples that are real helpful. And I know you guys are going to like this part. Here's an example of an assignment of deeded trust. And if you look at the date it was recorded and the recorder of deeds, you'll see there's a date of 3/27/24. It's important to look at the date that the assignment's recorded, because on that date, let's make sure that that lender even existed, or the assigner existed. And as you can see in the body of the assignment, it says for value received, Mortgage Electronic Registration Systems, which is MERS, as nominee for Financial Freedom Acquisition LLC, its successors and assigns, does hereby assign and transfer to the Secretary of Housing and Urban Development, that's HUD, this assignment. And let's look at Financial Freedom Acquisition LLC and its successors and assigns real quick and see what we can find out about that. Okay, so I looked online, because you can Google just about anything, and you can see here that on March 19, 2009, which was a long time ago, Financial Freedom Acquisition LLC went defunct. The Federal Deposit Insurance Corporation was a receiver for these institutions, so they went defunct. Another thing you can do is Google it and find out as well. Let me show you something. Okay, so if you Google the name of the lender, which is Financial Freedom Acquisition LLC, ceased when, it'll tell you exactly when they went out of business and a key timeline of events. In 2009, as I showed you, is when it went through its major restructuring because the FDIC took them over. But you can see there that in 2018, they finalized the sale of them. So they didn't exist when this assignment was recorded in 2024. And that's huge because they have to exist in order to assign anything. Let's look at another assignment. Okay, here's an assignment of mortgage from Carrington's situation. And you can see that this is not a date where they didn't exist kind of argument, but the face of the assignment is not correct. It's saying here the mortgage date was October 28, 2005 for the amount of $686.7. Well, Carrington said he did not sign the papers on October 28th of 2005. He signed it in 2007. The way to figure that out is to look at the promissory note. So you can see his promissory note right here, and the date is 2/107, not in 2005. Again, there's the right amount and the right date. But guess what? If they don't have the information on the assignment correct, then it's considered void as well. Okay, the next assignment we're going to look at is an assignment that was recorded on 5/1/2020, and this one went to a trust. As you can see here, it's the RASC, Pass-Through Residential Asset Securities Corporation Equity Mortgage Asset Backs Pass-Through Certificates 2005 AH1, whose address is, and they say, in care of PHH Mortgage. Well, let's take a look at a SEC filing, and this one is a Form 15. And you can see this Form 15 shows the RAS Series 2005 AHL1 Trust ceased. And let's see when they ceased. Here we go. January 20th, 2006 is when they ceased operations. They did no more trading. So why would they accept an assignment in 2020 when they ceased doing trading in 2006? Again, that makes the assignment void. Okay guys, here's another assignment. Assignment of deed of trust where the assignor was Irwin Union Bank and Trust Company, trying to assign something to U.S. Bank. And if you look, the date of this assignment was 6/27/14. So, you want to know what's wrong with this assignment? I'll show you. Okay, so in this situation, the FDIC is saying that this financial institution basically was closed completely on Friday, September 18, 2009. They ceased to exist. And so, again, they cannot assign something if they never had it to assign. If they don't exist, they can't give it to the next party. So that makes this assignment also null and void. Okay guys, I hope this was educational for some of y'all, and you can always send me an email to foreclosurehelp777@gmail.com. If you have an assignment that you want me to examine, you can send that to me and I will look at it for you and give you some hints. Or you can leave comments below and I will answer you. And as always, everyone have a blessed day.